Good evening and welcome to Community and Economic Development Fireside Chat. We're so happy that you're here to join with us. And today, as everybody know, that April is National Fair Housing Month, and throughout the month, we have been doing different activities all over the city of Albany, and we are trying to bring awareness of what fair housing is all about. We are blessed this afternoon to have with us from the Georgia Equal Opportunity Commission, Miss Mary Melvin, who's the director of the Fair Housing Division. So we are going, Miss Melvin, before she took on this position with Georgia Equal Opportunity Commission, she was a Fair Housing Division director. Prior to this, she served as a compliance investigator with the Georgia Department of Behavioral Health and Development Disability, conducting statewide serious incidents regarding an alleged of abuse, neglect, and exploitation cases. Prior to making Georgia her new home, Mary enjoyed serving her North Carolina community as a compliance officer with North Carolina Human Relationship Commission, which is also a fair housing assistant program, and completing classes through the Patricia Roberts Harris National Fair Housing Training Academy in Washington, D.C. So you see, you all, we have someone here with some expert to talk about fair housing. She's currently taking her classes, her last class to get her master's degree in industrial organization psychology at the Grand Canyon University. She holds a bachelor's degree in sociology from Shaw University in Raleigh, North Carolina, and an associate degree in special education from Vance Granville Community College in Henderson, North Carolina. She is a certified investigator by the Council of License Enforcement and Regulation and Labor Relationships Alternatives, Inc., and a certified mediator with the Edna B. Sparling Conflict Resolution Center and the Justice Centers of Atlanta. In addition, Mary completed the Carl Vinson Institute of Government Management Academy from the University of Georgia. So we are blessed to have her here. Everyone who's on here, join. If you have any questions, please put them in the chat box. And as we go along, we will answer the questions. If we can't get the answer today, we will take these answers down and we will get back with you with the correct answer. So it is a participatory hour that we're going to spend talking about fair housing. So please feel free to ask us questions while we got such knowledge here with us. So I'm going to turn everything over to Mary Melvin of the Georgia Equal Opportunity Commission. Welcome, Mary.
Thank you, Miss Betty. I'm so glad to be here. This is an honor, truly an honor and a privilege to be here with the City of Albany for the Fireside Chat. So Ms. Jackson and other City of Albany staff will be monitoring the Q&A box. I'll also look in on it as well as much as possible. And as Ms. Jackson said, we'll respond to the questions as we can. If time will not allow us to answer some of the questions, then we would definitely get those answers to you. Okay? So good evening, everybody. So this evening, during our fireside chat, I'm excited about sharing this information about fair housing. With this being Fair Housing Month, it's such a special time for us to raise our awareness about fair housing, about your rights, about your responsibilities, and it's just a good time to have this discussion. Tell you a little bit about DCEO, and those acronyms for the agency that I work for, which is the Georgia Commission on Equal Opportunity. DCEO is a state agency under the auspices of the governor's office, and our primary purpose is to safeguard individuals from discrimination in housing and employment. DCEO's agency composition consists of two divisions. We have the Equal Employment Division and the Fair Housing Division. The Equal Employment Division enforces the Georgia Fair Employment Practices Act, which was enacted in 1978 to ensure equal employment for all state government entities, such as agencies, colleges, universities, and universities, and some local agencies that receive significant funding from the state. And the Fair Housing Division enforces the Georgia Fair Housing Law, which was enacted in 1988. And we also serve to protect individuals from discrimination in the sale, rental, and financing of a dwelling on the basis of 7 protected classes. And I'm gonna go back a minute. Dwelling, meaning residential homes. We do not serve in the capacity of protecting for commercials, okay? The 7 protected classes are race, color, national origin, religion, sex, familiar status, some know it as children, families with children, but the correct word is familiar status term, and disability. Both divisions have the privilege of investigating highly complex cases of discrimination. Georgia strives to eliminate systematic discrimination by making sure employers and housing providers are compliant with the law through enforcement. Often, discrimination in both housing and the workplace can sometimes take subtle or hard to identify forms, even though the policy that facilitates the discrimination occurs openly and in plain sight. And so our office is an avenue by which citizens can file complaints involving allegations of discrimination. Excuse me. It is our duty to ensure equal treatment of all Georgians by fostering a more open and receptive environment in which to conduct business, live, and work. At GCO, we're delighted to promote fair and inclusive communities and workplaces because equality is about ensuring that every individual has an equal opportunity to make the most of their lives and talents. It is also the belief that everyone should have an equal opportunity to enjoy life, and it should not have anything to do with where they live, where they were born, what they believe in, or whether they have a disability or not. Historically, certain groups of people with protected characteristics such as disability, race, religion, or gender have experienced discrimination in some form, and that is why enforcement agencies such as ours, the GCEO, were established because, as you all are aware, quality housing is a stabilizer that links people to other life opportunities such as employment, healthcare, education, transportation, and an abundance of services. So access to housing, is important. Now, each industry has its own set of language, right? In the fair housing business, theories of discrimination is important to us. The 3 types of discrimination: overt, disparate impact, and disparate treatment. Examples of an overt, and before I go here, go any further, if we were able to take a poll right now, I guarantee you most people would say they can name at least one time when they probably saw something that was overt, something that's obvious, So an example of overt, say a lending officer tells the customer, we don't like to lend home mortgages, loans to Native Americans, but the law says we may not discriminate, and we have to comply with the law. That statement violates the Fair Housing Act, and it prohibits, the Fair Housing Act prohibits against statements such as that. So that's definitely overt. That's something very obvious. An example of disparate impact, say, thinking about zoning, for example. So if the zoning requirements are imposed by a local municipality and they impose a zoning requirement that has the effect of excluding minority home seekers from living within the locality and the municipality can be held liable for discrimination. The Supreme Court affirmed the disparate impact theory in 2015, not too long ago, in the Texas Department of Housing and County Affairs versus Inclusive Communities Project Incorporated. I'm sorry. So this is a case where low-income families, were seeking to obtain affordable housing. They filed a lawsuit in Texas, and they won. It was a predominantly Black inner city area and too few predominantly white suburban neighborhoods, which perpetrated segregation throughout the state. So cities like Dallas and Houston, they've been able to experience the effect on disparate impact treatment. Now,
Miss Mary,
uh-huh.
can I ask you a question? You said this was a new law that was new policy that was put in place just recently?
No, I was speaking
Okay.
on the particular lawsuit that happened back in 2015.
Okay, the lawsuit. Okay.
Yes, ma'am. Yes, ma'am. An example of desperate treatment. Say a landlord refuses to rent to a family with children because he considers children to be too disruptive to other tenants. Or say a real estate agent only shows a prospective Hispanic home buyer homes in Hispanic neighborhoods because the agent believes that is where the purchaser would feel most comfortable, and the landlord or realtor are unable to offer a non-discriminatory reason for the difference in treatment. That's desperate treatment. Disparate treatment. Some people say disparate. So I'd like to spend a little time. Now, I don't want to take up all our time with the PowerPoint, so I may not spend a lot of time on each of the PowerPoints because I want to have some time for question and answer. And this is a pretty long PowerPoint, so you may see me skip through some, but just know that I'm able to answer your questions if you need me to. Okay. So next, we're going to examine the federal and state laws that are enforced by government agencies on federal, state, and local levels. Okay, so I want to briefly share some key legislative history pertaining to fair housing that illustrate historically how we arrived here. Okay, the Fair Housing Act is Title VIII of the Civil Rights Act. And the Fair Housing Act is one of the most important titles within the Civil Rights Act because it truly encompasses everyone. April is National Fair Housing Month, and 22 will this year mark the 54th anniversary of the Fair Housing Act of 1968. This landmark legislation was enacted to protect both buyers and renters from certain types of discrimination when seeking a place to live. Even though the law has been enacted for over half a century, the way it is applied and interpreted has consistently evolved. We are constantly changing according to what the whole world needs. While the Fair Housing Act is not the first law to prohibit discrimination in housing, it is the first to do so effectively. Following the close of the American Civil War, the Civil Rights Act of 1866 was enacted with hopes of affirming that all citizens are protected equally by the law, regardless of their race and color. Unfortunately, the Civil Rights Act of 1866 would go largely unenforced for over 100 years. So real change will not be seen until April 1968. Barely a week after the assassination of Dr. Martin Luther King Jr., Congress passed the Fair Housing Act. And just 2 months later, the United States Supreme Court issued their decision in Jones versus Alfred H. Meyer and Company, affirming Congress's authority to regulate the sale of private property in order to prevent racial discrimination. This decision paved the way for the Fair Housing Act to succeed where the Civil Rights Act of 1866 had failed. Basic principles of fair housing. The general public tends to associate fair housing with affordable housing. Most think fair housing is an income or socioeconomic issue. However, it couldn't be more different from affordable housing. Affordable housing is housing which deemed affordable to those with a median household income as rated by the national government or local government by a recognized housing affordability index. However, fair housing is simply the right to not only choose where you want to live, but be able to live wherever you desire and enjoy the dwelling without unfair treatment or experiencing unlawful discrimination. I'm going to just briefly run through this real quick. I mentioned it earlier, the 7 protected classes. So you see on the screen, the 7 protected classes are race, color, religion, national origin, sex, gender, familial status, and disability. So anytime we have a call or a written complaint come through our office, there are certain things that we have to consider to make sure that we have the authority to investigate that claim. And the claim must have be based on at least one of these. So that's where we have to start from. You know, does this claim have standing to be investigated? And that's one of the things that we have to take into consideration. So I'm not going to go through what is familiar status. Well, you know, maybe I should. Just quickly, out of all the protected classes, familiar status is the only one that may not be very self-explanatory. So if a person is not familiar with fair housing, familiar status is defined as, I'm going to just read the definition so it'll be very clear, okay? It's a parent, a legal guardian, or a designee of a parent or legal guardian that received written permission of a parent or legal guardian that is domiciled living with a child under the age of 18, or any person who is pregnant or in the process of securing legal custody of any individual who has not attained the age of 18. So that's the definition of
Can I add an example of that? I had a question
please.
that was asked with familiar status, and this individual, single person who was going to enter into fair doing foster parent. And because of the place that she was in a 2-bedroom, and the landlord did not want to allow her to add the foster kids onto her lease. You know, and they were under 18. That is a reasonable, or is it not, one of violating her right? Because the ordinance, our city ordinance does not whether it was, and actually it was a boy, 2 girls. It was actually 2 girls that she was, and they were going to be sleeping in the same bedroom, which she could accommodate that. So is that an example of discrimination?
Well, on the fair housing side of what you just described, I have to kind of pick it apart because some of it is described as not fair housing, some of it is. So on the fair housing side of things, it sounds like he's denying her the opportunity to rent if he's not allowing, you said, because I think I heard you say he did not want to allow her to add the child under 18 on her lease. Is that correct?
Correct.
Okay, then that's the fair housing part of it. And no, he cannot deny her housing. It sounds like he
Okay.
wants to deny her housing, and you can't do that. So yes, that part of what you just said would be basis to file a complaint and investigate to find out more.
Okay.
Okay. So that familiar status situation is very tricky. A lot of people have a lot of questions about it. And with and I understand that. One of the things that I say a lot of times at work is when people contact our office, they're usually in a crisis, personal crisis. And
Right.
we do not expect them to understand the fair housing law, the Georgia Fair Housing Law, nor the Fair Housing Act as we do, because that's why we're here. We're here to serve Georgia. And we're here to explain and answer questions and help people through that crisis as much as we can. So when it comes to the familiar status, a lot of people are confused, and it's understandable. Now, I want to share just a little about who is protected. I just mentioned the 7 protected classes, and I want to give you a formal definition of who's protected. Any aggrieved person, meaning someone that they believe has been harmed. Any aggrieved person involved in a residential transaction, that means a rental or the sale of a home. Okay, claim to have been injured by a discriminatory act, believes that such person will be injured, believe that they are going to be injured. Say this comes up a lot. I'm about to be evicted, and I believe that I'm being discriminated against. Now, they don't have to wait until they're evicted to say that they've been harmed. Now, I'm not saying that being evicted is the basis of being is for discrimination, but what I'm saying is that could be part of an issue. So when you think about something that's about to happen, and you believe that is a discriminatory act, you can file on that as well. But it needs to be connected to the protected class that you are in. But so persons can be an entity of government, entities, corporations, fair housing organizations. During our case investigations, we refer to aggrieved persons as the complainant, and we refer to the person that they're filing about or against the respondent. So just a little definition and language for you. Covered dwellings, briefly, as you see on the screen, I'm not going to name them all, but basically residential homes.
Now that's one of the areas that a lot of questions ask. If
Okay,
a
I'll go back to
duplex.
it.
Yeah, let's go back to a duplex. I do get a lot of if a owner of the duplex is living on one side and that's connected to joint, does he or does he not have the right to dictate who can live on the other side?
First of all, you can't, because of the Fair Housing Act, you can't dictate who lives there. That's discriminatory in itself. Well, maybe I should take that back. Basically, you can't say, I'm not going to rent to a certain class of people.
Okay.
That's discriminatory. Okay. Now, if that person is living in that home in that other side of the duplex, there's a section that I'm going to get to later on in my presentation about exemptions. And we'll talk a bit more about that then, okay?
Okay.
So save that question.
All right.
All right. Potential respondents. As you see, it could be almost anyone that has anything to do with the decision as to whether someone lives in and or by a residential home. Let's see here. So this is quite a bit, and Let's see, do a time check. 6:26. I'm not gonna go through all of this because I do want to get to some of the stuff that you already asked me about. So if you forgive me for a second, I'm going to go through this, okay? I will share this. Discriminatory housing practices, common misconceptions. I want to take a moment and cover some subject matters that the general public contacts our office seeking assistance. The following are a common misconception. And here again, like I said, people that don't work in this office are not expected to know this until we let them know that, okay? But unfortunately, none of the listed issues are covered under the Act. Our office does not handle Georgia landlord-tenant grievances. If someone is having an issue with maintenance repairs or unsanitary living conditions, they should contact code enforcement. That happens a lot. And with understanding, if someone is in a crisis, someone's dealing with a situation, and they go online and look up and they see fair housing, or they see anything about housing, a lot of people automatically, contact our office, which is understandable. And that's when we are charged with explaining to them what we can do, how we can serve them, and connect them to the correct agency that can help them with that. So, as I stated in the beginning of the presentation, complaints alleging disability discrimination are the most frequently filed complaints. Actually, I didn't talk about that a lot, but they are both nationally and statewide here in Georgia. That's a huge area that we cover a lot. Okay, disability is one of the protected classes, and that has so many factors and components to it. Let's take a look at 3 major disability laws. It's important to first have knowledge of the major laws associated with disability. Here are 3 primary federal laws that protect the housing rights of people with disabilities and relate to accessibility in housing modification. Section 504, the Rehabilitation Act of 1973. Bars recipients of federal funds from discriminating on the basis of disability. Fair Housing Amendment of the Act of 1988, which I mentioned earlier. It applies to the public and private housing providers, including state and local housing programs, as well as private developers and landlords. And the American Disabilities Act, known as ADA, of 1990. Title II of the ADA applies to the accessibility of the services provided by state, and local governments. Title III covers public accommodations of all types, common areas in housing, such as rental offices, meeting rooms, and laundry facilities.
So Mary, under the Rehabilitation Act of 1973, when we're talking about the federal financial assistance, that covers tax credit properties.
Covers what?
Tax credit properties. A lot of developers are doing tax credit properties with multi-units now. And so when it comes to disability and any federal financial aid that goes to a renter that may be living in that complex, that applies. Or does it not? Is that a form of discrimination, or is it not?
Well, when you say is that a form of discrimination, each case has its own uniqueness. So you have to, I can't just blanket say, yeah, that's a form of discrimination or not. You have to look at each situation, and you have to look at all kinds of things. Was it based on one of the protected classes? But if you're asking me if that property falls under this Section 504, if it receives federal funds and and it is barred from discriminatory acts as well. If that's what you're asking.
Yeah, if it was built with using tax credit tax credit from the state?
I'm not familiar with tax credit. I'm not familiar with that term, but I do know that if it's receiving federal funds for people to live using that money,
Mhm.
then it has to follow the act as well.
Okay, if they're receiving direct subsidy for their tenants, then it
Yes,
does
ma'am.
fall up. Okay, it has to be direct assistance. All right, got it.
Okay, so I'm moving my picture around a little bit.
Okay.
I had it perfect earlier. Okay. All right. I'm gonna look up that tax credit. I'm not familiar with that. I guess because I don't do public housing.
Yeah, well, it's not all public housing.
It's
It's
not
just it's not no. It's developers who use
okay.
it
It's the money source.
assistance to a lot of them,
Gotcha.
and
I
they get that
understand.
tax credit.
I
Yeah.
understand now.
Yeah, we really need you to look into that for us because that
Okay.
is one of the major issues and complaints that we are dealing with right now. So if you can
Okay.
look into that and get us some clarity on that,
I
that really would
will.
help us.
I will. Let me write that down. You said types credit.
Tax credit properties.
Okay. Yeah, that's a new term for me, but I'll look it up and get you
Okay.
about it.
All right. Thank you.
You're welcome. Um, you want to do a time check? 6:33. Let's see.
Yeah, I'm looking at the chat box, and right now I don't see any questions on my end.
Okay.
I know Shawnee is monitoring the Facebook one. I know
Okay.
she has emailed me to say so you can keep going.
Okay.
Like I say, we those the kind of the issues that I were talking just mentioned to you are some of the major concerns that we are getting. And you said I heard you say earlier that when you um get a complaint, talk about the timely to get that person has to file the complaint, or is it later in your presentation?
It probably is later, and most likely it is. And if it's not, you know what? I'm not sure if it's in this one or not. So I'll just go ahead and speak on it for a little bit. So
Okay.
that is an area that I know that causes some frustration for some people. When when a complaint is filed, the intake person is going to spend some time talking with that person and making sure that we have jurisdiction to even investigate the case. That's the first
Okay.
thing. Meaning, make sure we have authority to investigate that. And if that's established, that intake person will process that complaint within 5 days, and they're going to send the paperwork out to the complainant, the person that's filed the complaint, and we really need that person to send that back before 10 days. Okay, they need to
Okay.
really work on their end because they're contacting our office saying, "Hey, I need your help," and we're saying, "Hey, we're here to help you, but we need some cooperation. We need you to send that back." Here in Georgia, the complaints have to get their complaints signed and notarized. So
Okay.
it is a legal document, and it is important that they send that complaint back to us within 10 days so that we can process that complaint.
So is
So
that after they do the one online, or they mail in one? That's then you turn the investigator sends them something that has to be signed and notarized.
once they talk to, they can either, like as you know, they can call, and when they call, see the complaint has to be written in
Okay.
some way. Okay, so either they can call and the intake person will write it, or they can send information in through our online service. And either way, the intake person has to talk to them to, here again, make sure that we have authority to investigate their complaint. So after that intake person has sent them that complaint, they need to send it back to us within 10 days.
Okay.
So whether that's in, and if it's in this, PowerPoint or not, I don't think it is. But if it is, then we've already talked about it. We'll have to talk about it again. But
Okay.
that's important for people to make that quick turnaround so we can address it as soon as possible.
Okay.
Yes. I'm going to skip a little bit of this. Design and construction, that in itself would take a whole hour or two to talk about. But
Oh, with
and it
with
rarely
the new
comes up.
codes, with the new codes that they're putting in place for building and getting permits, a lot of the stuff that's under the construction requirements now are automatically just about taken care of. And
Well, no, we'll see here again. You got to separate fair housing from other stuff. And we
okay,
only have the authority to investigate issues that fall under the Georgia Fair Housing Law and the Fair Housing Act. Okay. Now, so when you mentioned that, I did go back, and I do want to say this. When it comes to the Fair Housing Act, for old construction, tenants pay modification. I'm sorry, for old construction, tenant pay modification to any building available for occupancy prior to March 13, 1991. Okay. For new construction, Fair Housing Act imposes design and construction requirements on covered multifamily buildings with 4 or more units only. Now, that's when you were talking earlier about, well, no, that's one of my exemption things. I'll say that later. But design for first occupancy after March 2nd, 1991. Okay. And there's 7 design requirements that the Fair Housing Act requires of the construction in order to meet the Fair Housing Act criteria. There's a lot going on with that, and that rarely comes up. For example, I'll give you an example. So there was a situation where a lady was living in a triplex. I think it was a triplex. And she had some concerns about fair housing. Well, if her concerns were in, say, a residential dwelling that was not a duplex or not a triplex, she I'm sorry, a triplex she would have probably had a legitimate fair housing complaint. But because she lived in a triplex, and that's one of those exempted buildings, it didn't fall under our jurisdiction. So that this design and construction thing is very tricky, and truly each case is unique. So we have to peel back the layers for each case to make sure that we have the authority to investigate that case. So that is something that we spend a lot of time working on and making sure that we are correct with that.
So what would be an example of one that does not fall up under you that you've got a complaint about? A triplex, the triplex,
Yes,
because
ma'am.
it's 3 or less. Okay,
Yes,
that's
ma'am.
the biggest one.
Mm-hmm.
Okay.
Now, earlier, I think I skipped over something that I need to go back to right here. Reasonable accommodation disability. And this is, and I know I mentioned earlier how we get a lot of complaints involving disability. So I did want to spend a little time with this, okay? And the big, huge thing that comes up a lot are the emotional support animals. And when someone that is disabled, if they report that they're disabled, or they have proof that they're disabled, or deemed that they're disabled, and they have an animal, and they have identified the animal as an emotional support animal, the animal is not a pet. and cannot be required to pay pet fees. I cannot tell you how many times we have to address that issue. That comes up all the time. And here again, people that don't work for DCEO or such agencies are not expected to know that. And that's why we don't have any problem educate people about that. Okay. But that is a huge thing that comes up all the time. I mentioned about the service animal, emotional support animals. I'm going to skip through a lot of this. Current pandemic challenges. Let's make this a current situation.
Okay.
This is not, and if you can, I hope you can see the screen very well. This is not an exhaustive list of some of the current challenges for fair housing that have been we've been dealing with throughout the pandemic. But with any crisis, it is those who are already vulnerable in vulnerable positions who are going to have the earliest impacts and hardest impacts. For the sake of time, I will not cover each issue in depth, but housing instability is a prevalent issue. When it comes to the lack of affordable and accessible housing, it's extremely difficult for individuals who are homeless or who lack stable housing to find a place to stay long-term to limit exposure to COVID-19 or to be required to stay at home due to a shelter-in-place order. And in terms of an increase in disability and race-related cases because of COVID, wow, this is a situation that is constantly changing and evolving. Originally, discrimination and harassment started to occur against people of Asian descent based on false claims that they caused COVID or were responsible for spreading the new coronavirus. Recently, there have been more reports of the same against people who appear to be Italian or Jewish. And now that so many people all throughout the country have been exposed to the virus, there's also alleged discrimination occurring against people who have or are perceived to have COVID, which is against the law. Disability is defined broadly. The Georgia Fair Housing Law prohibits perceived disability and denying a reasonable accommodation for an individual with COVID-19, among other prohibitions. And lastly, the effects of eviction are expected to be long-lasting, as you probably know, Ms. Jackson. It's it's going to be a long time before our communities can recover from all that's going on right now. A lot of people are unaware of what exactly an eviction moratorium means. We went through that for, I'm not sure how long that lasted, but it was a while. And I still think that our communities are still feeling some effects because some court cases, some courts were backlogged, as you probably remember. And right. I'm not sure how many of the counties around, I think what Georgia had, 150 counties?
159, counties.
Okay, 159. Yeah. And I can only imagine, how many courts are backlogged and are still dealing with evictions from the moratorium, from the moratorium ending. So, we're dealing with a lot of issues behind this pandemic that we're still living in.
Because today we reviewed a lot of the renter laws that Georgia Ike and other advocacy here in Georgia was fighting for to get passed, because Georgia is one of the states that has very little protections for tenants and renters.
Yes,
And
ma'am.
but back in 20, we did get one passed, but the ones that they had on the books that they voted on this past week or so, they did not pass. So our
Um,
advocacy for renters has to increase, and be talking to all of our state, local officials about putting some protection in for renters, and
okay.
just giving them the um, time frame of right to cure. That did not pass. That was one of the ones that was pushing the right and giving them that 7 days before they could file the eviction notice, that right of cure. That did not pass, unfortunately.
Mm,
So yes, Georgia has very, very light tenant protection laws right now. So that is something we all need to be pushing to get put in place, because it doesn't seem like the pandemic is going to end anytime soon. So, and it's constantly changing, and
yes.
unemployment is changing, reduction in income, everything is increasing. So it's going to get a lot tougher to stabilize housing for everybody, and there got to be some give and take.
Yes, I agree.
Yeah,
I
so
agree. I was
we
just
gotta.
watching the news earlier and I saw something about a new strand or something. So it's
That's
just,
coming.
yes.
Yeah. Mhm.
So whenever I see something like that, I quickly think, how is that going to affect housing? How is that going to affect people being able to rent and buy and live, you know? So it's a constant thing that we have to stay on our P's and Q's about, making sure that we're ready and able to serve the people that need us and give them guidance to the other agencies that can serve them better if it's a situation where we don't have jurisdiction on.
Yeah, because one thing our tenants and renters have to do, and we have to encourage them to open the line of communication up with their landlord. Do
Yes,
not disregard those letters. Do not disregard,
right,
communicating with your landlord and or the property manager. Open up that line of communication. Let them know what's going on.
I
Both
agree.
sides is suffering. So we have
Mhm.
to do that. We have to encourage our callers to do that. Open that line of
Right,
communicate. Talk about it. Come up with something that's fair for both of each other, but don't just ignore each other and use the legal system to
right.
gain
Beat them
whatever.
up.
Yeah,
Hmm.
to do that. We gotta do that. We gotta, and that will help if we can just get that everybody comfortable with doing that.
I agree. I agree. Let me give you an example of how communication can help. One of the things that we see a lot in our office is the issues surrounding reasonable accommodations and reasonable modifications.
Mhm.
And one example that I love to share is uh, a situation where, say, a tenant uses their money from their disability money, SSDI, say they use that money to pay their rent, right?
Mhm.
And their their mail is not delivered to their house until that evening. You know how sometimes your mail might come early, it might come late. In their
Come late.
community, the mail is delivered late. And that's how they receive their money, is through US mail, right?
Right.
And when it does um, appear in the mailbox, it is on the 5th. I'm just gonna throw something out there. It's on the 5th. And the rent is due on the 1st. So that means that technically they will always be late for paying
Mhm.
their rent, but it's not something that they can control. A great opportunity for communication would be to talk with that landlord. Even from the beginning, if they move in there receiving that, if they move in there with that same situation, it's best to go ahead and have that conversation as early as possible.
Right.
And
Right.
ask, can I have this as a reasonable accommodation? Or are you willing to allow me to pay my rent on, say, the 6th of every month without penalty, without late fee?
Mhm.
That would be that would be awesome if people could do that. But unfortunately, sometimes people don't take that next step to talk to people. They think, oh, I'm gonna pay it, but then they end up incurring late fees or worse,
Right.
being evicted, all because they didn't take the next step to have a conversation with their landlord. So
Yeah.
situations like that could just be avoided if you just have a good conversation.
And that is a big fear for a lot of ones that did have fixed income when we had the EPRAP money to help rent assistance. That was one of my questions that I asked a couple of the clients.
Okay.
Did you let the landlord know up front that your money comes on this day? I think the new ones is based upon their birthday, and if their birthday falls at the end of the month and or middle of the month and not the first, make that known at the very beginning, and you can show them, here's a letter,
Right.
it says to do that. And I was surprised that a lot of the tenants had not taken that step and or believe that the landlord would even be open to that.
Right.
If you can show I'm gonna pay, but it's no, and not get the, and then I start showing them, you know, how much late fees that they are paying. If you
Right.
add this times 12,
That's a
can imagine
lot.
what you can do with $600. That's a lot of
Okay.
money for, yeah. So it is. We want to encourage everyone, if you are facing those types of dilemma, because there was some testing done with the mail, and where it's supposedly now to mail 7 days, it is
Mhm.
now 10 to 12 days
Right.
before. So you almost got to mail things 10 to 12 days earlier than the due date in order for it to get there on the due date.
I
And you
agree.
got the money, and I think this, and it may be designed to push everybody to do automatic drop. I don't know, but they did some
I don't
tracking.
know.
They showed us that day, and I was like, that's what people have been complaining about. Their payment was sent, they sent it on the first, and it didn't show up to the people till the 15th or after, and
Right.
then they got a late fee. Yeah, so
Right.
when you get those kinds of things, if people in our audience that you're listening, just talk to your landlord about them, especially with your fixed income and it's coming that way and it's not automatically into your bill, it's coming through the mail, because everybody don't have accounts or cards. Show them that, and I'm sure they would be open to sometime working that out if you be honest with them and forthcoming to what your situation is.
Yes. Yes. And not wait
Yeah.
till the situation gets out of hand and, need to resort to all kinds of, ways to address it when you could have addressed it from the beginning.
Yeah, because it costs the landlord money to go through the eviction process. It's
Yes.
not cheap. It's not free. It's not cheap. It hurts everyone, and it's much easier to work something out with a tenant than to get you out and got to do the place all over and get that. So it's
Right.
compromise on both sides, but we got to
Yes.
open up the line of communication.
Yes. Time is money.
Yeah, it is. And we're
So,
almost, I guess we're about 6 minutes into
yes,
before this is
ma'am.
coming to an end. And I'm going to check the chat box. And I know, like we were saying, the time frame to file, it has to be when you think you've been discriminated, you have to file that discrimination within 12 months of it happening, right?
Correct. 1 year. Yes, ma'am.
You have 12 months to do that. And am I hearing you saying your office is open to phone calls versus filling that application out online to
Well,
start
I
the
just say,
process?
well, not versus, because the online is always an option. And that's a
Okay.
really good way to get your details in there. Some people do better by calling. And if they need to
Okay.
call, then they can call. But
You're open to that.
we like the online as well. So
Okay.
it depends on what they need.
Okay. That, and yeah, that time frame, and you said once they do that, you do respond within 5 days of sending that back, and then they need to immediately sign it, get it notarized, and get it back to you so the investigation can begin.
Yes, ma'am.
Okay, that's helpful.
And
um
the timing is off and something's going on with them, because here again, we're in the pandemic. So you don't know what's going on with people, but communication, just like they need to communicate with the landlord, they communicate with our office as well once they file a complaint if something's going on, you know. Because if it's not, received back in 10 days, we can close it, even though they can still file you know, they can file, they can still file again, as long as that situation that they're talking about happen within the 365 days. As long as it's timely.
Okay. And if it's, so when they do file and it's something that is not addressed by your office, then you make referrals to them to who they do need to contact to try to get some assistance or to remedy the problem.
Yes, ma'am. We will let them know what agency can assist them. Not necessarily referral, but we will say if it's a landlord tenant issue, we'll send them that in the right direction. You know, if it's a code enforcement issue, we'll send them in that direction. Things like that.
Okay, that's good to know. So they will get some answer. It's
Yes,
just not a
ma'am.
flat no, we can't help you. That is good
Correct.
for everybody to know. Because I one of the things that we tried to get the consumer to understand is that you have to speak up. Now is the time to speak up. You have to say something. You cannot not, and you have to be willing to put it in writing to you so that it can be addressed. You know, yeah, you can make the phone call and they'll send you the form, but you got to be willing to put it in. And I understand about retaliation, and I know there's a limited amount of housing. It's real. It is a very limited amount of housing. So I understand the fear that if I do that, then I'm going to be retaliated. Nobody else is going to rent to me. It's going to go on my record and all that. But if we don't say something, and if we don't speak up, then we can never get rid of this problem. So one last quick question I want to ask you, based upon the classes that we have in place, and it's been 54 years since this ICE been in place, do you think we have overcome the protected classes that's on the books, and now it is time for Georgia to add some more protected classes to that, or update it or amend it?
My personal, this is not a GCO thing.
Yeah, your personal.
My personal opinion is that we have a long way to go. I feel that we have done a lot of good work, and I feel that we have still a long way to go to say that we have overcome those issues that were addressed back in 1968, all those issues that came up, they're still real. And I know that because we're still processing cases. You know, we're still processing a lot of cases. A lot of people have real issues, and that we, are happy to serve and happy to help them with. So I don't see us at a place where we overcome anything. Okay. I see that we've made a lot of improvement. And here again, my disclaimer, that's my personal opinion.
Yeah,
that's my personal opinion, that we have a lot of work to do, and we've done a lot of good work.
Yeah, because based upon on these things that you have on the screen now with the pandemic challenges, it's just adding more to the fire that we as advocates for fair housing, it's got a long way to go. And the lack of affordable, accessible housing is issues all over the country. It's not just in one designated area or two wards. One designated, it's everybody. So we've reached the 7 o'clock hour. We want to thank Miss Mary Melvin from the Georgia Equal Opportunity Commission office for being with us this hour doing the Fireside Chat. It is always a pleasure of having her and talking to her. I think every time I talk to you, I hear some new insight. There's some new insight of how to have. So we really appreciate that. And if for everybody who's listening, feel free to contact us later, send us emails, and we'll answer your questions. And once again, thank you, Ms. Mary, and we will be in touch with you at a later time. And thanks everybody for joining us tonight, and we hope to hear from you soon. Remember, fair housing is not an option, it is the law.
That's right.
Ms. Mary, would you like to have anything to close us out?
That was perfect. I'm just I love that. It is the law.
It is the law, right? It's not an option.
Thank you.
All right, thank you. Good night, everybody.
Good night.